Breach of contract and remedies. Now we'll look at what happens when, after a fully executed contract that contains all of our requisite elements, nonetheless falls apart because one of the parties refuses to perform or is unable to do so. We will define a breach and a waiver of a breach. We'll look at the specific remedies for breaches, and then finally we'll discuss language to put in our contracts if we want to limit the amount of damages that we incur for a breach ahead of time.
What is a breach? A breach of the contract is when one of the parties fails to act or perform in the manner called for in the contract. For instance, in our used sales car contract, the buyer is supposed to pay, that's their duty, and the seller is supposed to provide the car that was agreed upon in the contract. So if the car received is not the one described in the contract, that would be a breach on the part of the seller. If the buyer doesn't pay the exact amount that they were required to, or if their payment fails, their check bounces, or credit card is declined, or however, whatever form of payment they used, that would be a breach on the part of the buyer. An anticipatory breach. An anticipatory breach is when one of the parties lets the other party know that they will not be able to perform under the contract. So essentially, you let the other party know ahead of time that you will breach, as opposed to a regular breach when at the time that the performance was due, you don't perform. An anticipatory breach is you know ahead of time that you're not going to be able to perform. It's sometimes known as an anticipatory repudiation when a party expressly declares that performance will not be made when required. So let me give you an example. Let's say you have a sales contract where a seller is providing goods to the buyer. For instance, let's say Samsung is selling 100 cases of some of its electronic equipment to Target for resale. And because it's a large order, Samsung and Target enter the contract in, in February of 2019. But the 100 cases won't actually begin to ship until October of February 2019. So the date of performance is October of 2019. The contract was entered back in February. If at some point before October, let's say August, Samsung realizes it won't be able to ship the 100 cases to Target that it agreed to in the contract, they could let Target know ahead of time, at that time, that it won't be able to perform in October as promised. Because Samsung in that instance would be letting its buyer know before its performance was due, that would be considered an anticipatory breach or repudiation. Now, an anticipatory breach can be done by declaring that calling somebody up, telling them you won't be able to perform. You send it in the email, you send it by text, you send them a letter, or you can have an anticipatory breach by conduct, where something happens or the seller or buyer does something that makes it clear ahead of time that they won't be able to perform. What's a good example of that? Bankruptcy. So if Samsung is supposed to deliver 100 cases of electronics to Target in October 2019, but by June of that year, Samsung has declared bankruptcy, Target could consider that an anticipatory breach, an indication that Samsung would not be able to perform under the contract, and they might infer it by their conduct, the fact that they're in bankruptcy. Sometimes the breach can be excused. I'll give you an example. Almost everyone in the class probably is engaged in some sort of lease arrangement, lease contract, where you are renting space for your room, and you received a contract where the lessor agreed to provide you the room in exchange for your payment. Sometimes, and oftentimes, leases will contain a provision that if you are late with your rent payment, a late charge will be added, and it's sometimes a stated amount, like $25 if you're late, or a percentage of the monthly payment will be added, and it's due within a certain time frame. Alrighty, so all of the lessees, those of you who are leasing a room, are contractually obligated to pay rent. Most leases will say or provide that if you do not pay rent on time, a late fee is added. So let's assume that you were late the month of September and a $25 late fee was required. But when you went to pay the late, to pay your September rent, the landlord did not require you to give the late fee. They didn't say a thing about it, so you didn't say anything about it. Then in October, you were late again, and just like in September, you decided to pay maybe a week or so late, and you did not add the late fee, and the landlord didn't ask you for it. Then in November, lo and behold, you're late a third time, and this time the landlord says, guess what? I'm tired of it. You owe me late fees, not just for November, but also for the previous months. Now, you might try to argue that the landlord had waived their right to collect the late fee because in the previous months when you were late, they never moved or acted to enforce the late fee provision. When there's been a waiver, the party waiving the breach loses the opportunity. They can't take action to enforce what they normally would have been um, had the ability to do. So sometimes parties will claim, yes, you had the right to do this, but you waived it by not enforcing it. Now, what does this do? When you have uh, the ability to bring up this idea of waiver, it does make uh, people in contracts, it teaches them that you better be hard-nosed about the provisions and always enforce them because you don't want to lose the ability later down the road. Because maybe the landlord was being nice the first 2 months trying to give you a break, but then they realize this is going to be a repetitive thing with you. So they say, no, I'm going to enforce all the late fees, not just for this month, but the previous ones. Well, the landlord has to be careful in that situation. If you could successfully argue that they waived their right to collect the late fee in the previous months, then the landlord would lose that ability and they could only enforce it in the current month. But as I'm going to show you in a couple seconds, there is a way that the landlord can protect uh, himself by putting something in the contract to prevent waiver. And we're going to look at that in a few seconds. But generally speaking, a waiver can occur if a party repeatedly fails to invoke rights that they have under the contract. The other party could claim, yeah, you had the right to do that, but you never did it. You've lost it. You've waived it. So let's look at that in uh, with more specifics. A party may declare a waiver or express it by allowing the other party to continue performance. In our example, when the landlord allows you to give your late rental payment without requiring you to pay the late fee, that's how the waiver is created. They have been they have given up their ability to require the late fee when they keep allowing you to do so. Scope of waiver. The waiver only covers the exact conduct that's being um, excused. In other words, in our situation, the waiver only extends to late fees for the month that they didn't ask for it. Now, how can a party try to prevent this from happening? Um, as usual with anything about contracts, is you can put something in a contract about it, put a provision that says that waiver is not allowed. So before I tell you how we do it, I want to give you an example of why you want to do it. So let's look at our landlord situation. Most of the time when you're dealing with someone in a landlord lease situation, you're not actually dealing with the property owner. You're dealing with employees. You're dealing with folks who work for the owner of the property. Sometimes in some of your accommodations, the person collecting the rent from you might be another student who works for the dorm or for the apartment complex, and maybe they don't collect the late fee from you because they don't realize they're supposed to, they forget, or the situation all landlords want to avoid. Maybe they're trying to hook you up, your friends, and they said, "Oh, nobody will realize that I didn't get the late fee from you. Just give me the money. We'll take care of it." Right? If you're the landlord, you don't want that kind of thing happening. You don't want your employees forgetting to do things, being ignorant of the fact that they're supposed to, or worst case scenario, hooking up other people. So, what the landlord would want to do is have a clause in the contract. And you can put a clause in your contract that says, even if I fail to ask for something that's in the contract, that does not constitute a waiver. It's called an anti-modification clause. It allows the landlord or whomever is a party is in the contract to expressly state none of the provisions in this contract will be waived or changed. So even if my employee forgets to ask you for the late fee for 3 months in a row, the contract puts you on notice that a late fee was due and it's still owing, even if no one asks you for it. And that's what any business owner will want to do. You would want to have an anti-modification clause in your contract saying that waivers do not modify the contract, that the conduct of my employees who fail to enforce things that are in the contract is not going to get rid of that provision. And it really makes sense to do this because that's the point of a contract. You want to put that in the contract so that people will know, no, you don't rely on the cashier or the person taking the payment. If I have it in the lease that you owe a late fee, then you're going to owe the late fee. So now we know that when a party does not perform their part of the contract, that is a breach. We also know that if a party has a provision in their contract and they don't enforce it, they might lose the opportunity to enforce it later. That would be considered a waiver unless they've put a clause in the contract called an anti-modification clause that prevents waivers from changing a contract. I also mentioned to you that if a party lets you know ahead of time that they will not be able to perform under the contract, that is called an anticipatory breach. Now we're going to look at the remedies for breaches and anticipatory breaches. So let's look at anticipatory breach. If a party lets you know, let's go back to Samsung. Samsung lets Target know several months ahead of time that they won't be able to deliver the agreed upon shipment in their contract. In that instance, Target, the buyer, would have several options available to them. Their options available to them are what we call their remedies, like what they can do, what action they can take in response to the breach. First of all, they could just wait. They could state that the performance is still due at the proper time and wait and see if Samsung will be able to perform. That's called wait for performance. They Target or whomever the other party is could treat the anticipatory breach as a repudiation of the contract. All right, you breached the contract. I'm going to sue you right now. So they could go ahead and pursue all of their remedies immediately. So even though under our example, the goods were not due to Target until I think we said October or November, if Samsung lets them know in the summer they're not going to be able to deliver the goods, Target could choose to go ahead and sue them or pursue any of their other remedies that we'll look at in a second, right then in the summer, immediately. The third option that a party could have if it is alerted of an anticipatory breach is that it could just decide, you know what, if you're not going to be able to perform, thanks for letting me know ahead of time, we'll just cancel the contract. This is the easiest remedy, to be quite honest. This is probably the one that most parties who are giving an anticipatory breach are hoping that the other party will use. Uh, and this is why you would let someone know you're breaching ahead of time. Samsung may have made a decision that perhaps if we let Target know months ahead of time that we won't be able to deliver the goods, they will just cancel the contract with us, go find their goods somewhere else. We'll give them their money back, and we'll be back to where we were when we started. And that is one of the main reasons a party would let the other party know ahead of time that they won't be able to perform. Uh, and this can work from either end. Let's say it was Target who realized they won't have the cash flow or the money or the credit line to purchase all of the goods that they initially had planned to, that they'd entered into the contract with Samsung for. They could choose to contact their seller and say, I'm sorry, we won't need those goods anymore. We don't have the ability to sell all of those goods at this time. Uh, can we cancel this contract? And they might reason that if we let them know ahead of time, Samsung would have time to sell those goods to somebody else. So there are really good reasons why you would uh, give another party, you make an anticipatory breach or repudiation of the contract so that the other party could make other arrangements. But you have to be aware of the fact that the other party doesn't have to make other arrangements. They don't have to cancel the contract. They could choose to bring a lawsuit immediately or pursue any of their other remedies that we're going to look at in a minute. So, what are our other remedies for just a regular general breach that occurs at the time the contract calls for performance? So, some general principles. Courts will provide quasi contractual remedies when a contract is unenforceable. What does that mean? That means if there's some problem with the contract, remember we looked at all the elements of the contract. Let's, maybe the consideration, there was no consideration present, or one of the parties made a mistake, or both of the parties made a mutual mistake. But if the court believes it would be unfair to let the other party keep the money or not have to perform, and sometimes the courts will then say, even though that there was no contract, or the best example, if the contract was not in writing when it needed to be in order to satisfy the statute of frauds, but the court can tell that the contract did take place, but it wasn't in its proper form. Sometimes the courts will go ahead and give damages even though there's technically no contract. And when the courts do that, they don't go with what the parties had agreed to in their contract that didn't work out. The court would give damages based on what they would call the reasonable value of the services. So you're not going to make any profit, but you're going to get the reasonable value. What's an example of this? Let's say um, you had paid someone to, you'd entered in a contract for someone to put a fence around your yard, and the fence was going to cost $1,200. That contract should have been in writing because you could argue that that was a contract for the sale of goods over $500 because there was a fence involved. If the person putting up the fence was actually like bought fence material and was putting it around your yard, those are the goods, even though there's also a service there with the labor. But that whole contract, since it's $1,200, should have been in writing. So the homeowner allows the uh, the fencing personnel to put the fence up and then doesn't pay them and says, guess what? The contract should have been in writing. You can't prove this contract. I'm not paying you. That would be kind of squirrely, but it could happen. If the parties went to court, the fencing company, and they tried to hold the homeowner to the contract, the homeowner could defend and say there was no enforceable contract here because this contract was not put in writing. It violates the statute of frauds. Now, homeowner might think they had a slam dunk. Hey, it was supposed to be in writing. In that situation, courts would look at, they would rule, yes, you're right, there was no contract. But they might decide to use a quasi contractual remedy, i.e., there's a fence around your yard. Nobody does that for free. This contract wasn't put in writing as it should have been, but it would be unfair and a windfall to you, homeowner, to get a free fence, and unfair to the fencing company to have put the fence up and get nothing. So what the court might do is award reasonable value of the services. So they look at how much did the fence cost? Okay, maybe it really only cost $700, and the rest of that $1,200 was the fencing company's labor and their profit. And what they would do is just award the reasonable value, which would be the $700. And in that way, the fencing company got something. They weren't completely cheated, but because there was no actual contract, enforceable one, they wouldn't get everything that they had expected had there been a contract. Monetary damages. This is what most people think of when there's a breach of contract. What do they want? They want money. They want their money back, or they want money for the things that didn't work, or they want to get the money they were supposed to get. We've got three overall categories for damages. The first is compensatory damages. Those damages are for the actual loss. They're to for compensate the party for the breach. So they're typically whatever the actual contract value was. For instance, in our fencing contract, if the cost of the fence, the contract for the fence, had been in writing the way it was supposed to, compensatory damages in that case would be the $1,200 that the fencing company expected to receive for a validly entered contract. Nominal damages. A nominal damage is when you're not really trying to be compensated or made whole for something. It's really about just establishing that you had a legal right. Sometimes you'll hear cases where someone went to court and they sued for $1. And when they're suing for $1, they're not really trying to get money from the other party. They want to go to court and have the court declare that they are right and that the other person was wrong. And so they just ask for minimal or nominal amount of money to have the court rule in their favor and to establish that the other party was wrong. There was a famous case not too long ago about this where Taylor Swift sued a reporter for $1 because she wanted to establish that the person had violated her privacy. And because she is wealthy, she wasn't looking to get money from the reporter. She wanted the court to declare that what that reporter did was wrong and that he was violating her privacy. And she went to court, and there was testimony, and the jury found her witnesses to be accurate, and the court ruled in her favor, and the reporter had to pay her $1. But she established that what he was doing was wrong. And then finally, punitive damages. Punitive damages are like the word suggests. It's to punish. Punitive damages exceed and are over and above a person's actual loss, the actual damages. And they're imposed to punish people. Now, people like the notion, plaintiffs do, of punitive damages because it means not only will I get my compensatory damages, what I actually lost, but the court will give me extra money to punish you. These are hard to get. You rarely get them for regular contract actions. When you get punitive damages, sometimes they are in personal injury claims where someone was hurt by somebody else's actions. Um, you can get them when a corporation has been really egregious, like not only did they make a product that hurt somebody, but they knew about it and they hid it, they lied about it, they kept it secret. In those kind of instances, you can get punitive damages. Direct and consequential damages. Direct damages naturally flow from the breach and include incidental damages. Okay, let's talk about that for a second. Let's go back to our fencer. When the fencing company puts up the fence and they had charged you, the contract provided you'd sell them, you pay them $1,200, and you don't, and let's say the contract was in writing, so it was enforceable, their direct compensatory damages are $1,200. Their direct damages are $1,200. That is a form of compensatory. Incidental damages are also a form of compensatory because you're getting compensatory is to getting damages back for what you actual lost. If the fencing company had to spend extra money trying to enforce the contract against you, you didn't pay them, so they spent time, uh, FedExing you bills and sending you certified mail to try and uh, get your attention and get you to respond. They could add these extra expenses that they incurred that are a direct result of your breach of the contract when you didn't pay. If you had paid, let's say you paid by credit card and your credit card uh, payment doesn't go through and the company charged the fencing company a fee, or if your bank charged a fee because your check bounced, those those extra expenses that the fencing company had incurred because you didn't pay them the $1,200, they could also make an action to get those damages back. Those would be their incidental. So the direct would be the amount under the contract, the $1,200. Then the bounced fee charges, bank charges, Federal Express charges, things like that, that the fencing company had to spend money for and because of your breach would be incidental. And the direct and incidental together are a type of compensatory damages because they're trying to get compensated for their loss because of your breach. Now, consequential damages are a little different. Consequential damages do not naturally flow from the breach, but they occur as a result of the breach, and they had to have been foreseeable. For instance, let's go back to Samsung and Target. If Samsung created a special branded electronics that were going to be only available at Target, and then Target breached the contract and said, we can't pay for them. In that instance, Samsung's consequential damages would be the direct one, like whatever the cost was going to be for the 100 cases of electronics. They might have incidentals if they had spent money trying to get Target to pay. But if Samsung could also show that they lost profits in particular, or they were unable to resell those goods because they branded them especially for Target, those would be additional damages as a result of the breach. And if they were foreseeable, like Target knew that the goods that Samsung was creating for them would not be able to be resold because they were branded Target, then in that instance, that seller could make an action for direct damages, incidental, and consequential. And you can tell what consequential damages mean just by the root word. These are damages that happened as a consequence, as a result of your breach. Mitigation of damages. The law imposes an obligation on any party to try and mitigate, i.e., lessen the loss. Let's go back to Samsung. Let's assume that Samsung was selling Target just regular basic Samsung electronics that it could sell to anybody, to any company, any retailer. In that instance, when Target says, can't, we can't pay, we're going to breach the contract, in that instance, Samsung would be expected to mitigate their loss. They can't just sit around and wait for Target to pay them when Target says that they won't. Samsung should take steps to reduce their loss, like, for example, selling those 100 cases of electronics to Walmart or to some other retailer because they are able to sell them since they were just general electronics. And so the courts would require that when Samsung comes forward to sue Target for the breach, they're going to want to see that Samsung took measures to try to lessen its loss by doing something like reselling. Then we have a category of non-monetary damages. So in these remedies, you're not getting money. Most of the time, I'd say 90% to 99% of the time, what parties are looking for are money damages, like we talked about before. They're looking for compensatory damages, to make them whole, which includes direct, incidental, possibly consequential if it was foreseeable, right? That's typically what buyers and sellers are looking for. But sometimes they don't want money. So let's look at those. Rescission. Rescission is when uh, one party breaches and then the other party just decides, okay, we'll rescind the contract. I'll just rescind the contract. You can't perform. We'll just take it back. This is rescission is the legal word for canceling. We'll rescind the contract. We'll take it back. We'll cancel it. We'll just go back to where we were before we met. If any part of the contract had been already executed or money spent, even under rescission, then you should be able to get the part that was already expended. Action for specific performance. An action for specific performance is when you don't want money. You want the court to order the other party to turn over, give you, sell to you, make you do what you had agreed to under the contract. This is very rare. Courts don't usually order, at least not in civil courts, don't order people to do things. They will order them not to do things, but they typically don't order them to do things unless it's to pay money. One is because it's hard to get someone to do something. In the sense that, let's say you had a contract where someone was, you had, you'd hired an artist to come paint a mural uh, in your building, and they breach the contract and they say they don't want to, they don't want to do the job anymore. In that case, you really should just make an action for damages to get any money back that you have already paid them. Because if for some instance, for some reason, you decided to ask the court for specific performance, court forced that painter to come to my building to paint a mural. If the court would do it, they could do it, but they can't ensure that the painter would use the same quality that they would have, that the painting will be up to your standards, that it would be beautiful, it'd be whatever you asked. All they could do was tell them to do it. And then what happens would be a problem. So typically, specific performance is only ordered and only available if the subject matter of the contract is something rare, unique, or one of a kind. So what do I mean by that? Examples. Let's say you enter into a contract to buy some very rare baseball card from 1953 from some really famous um, person who played baseball, right? In that instance, if you'd entered into the contract, and let's say you were going to pay $1,000 for that baseball card, and the seller breaches and says, you know what, I've just changed my mind, I'm not going to sell it to you. That's an instance where you might want to go to court and ask for specific performance. Because even though you wouldn't have spent your $1,000, you can't easily go find that 1953 baseball card from some other seller. It's too rare. It's unique. So you want the actual card. You don't want to get to keep your money. And that's the kind of instance you need for specific performance. Usually you see this in when the subject of the contract is rare art, collections, sometimes vintage cars. Those are the kind of examples where you might be able to get a court to order the other party to give you the subject of the contract and not make the person pay money. Also, sometimes you want the court to order somebody to stop doing something. That's called an injunction. In this instance, again, the plaintiff is saying, money's not going to make me whole. I don't want money from the other party. I want them to stop doing what they are doing. Injunctions are often used like when a party is infringing your trademark or infringing on uh, making goods that um, are confused with yours. There's a famous case where a shoe designer started painting their shoes with red bottoms and red soles, and Louboutin, who was famous for making red-heeled shoes, took that other shoe manufacturer to court and they asked for an injunction. They didn't want money from that party. They wanted them to stop putting red soles on their shoes because it was confusing consumers. So that's the kind of time when you would get an injunction. A reformation of the contract. A reformation is, root word is to reform. When you go to the court and you ask them, can you fix, change, make this contract right? And that is generally to correct mistakes. But reformation is another remedy. You don't want to cancel the contract, you don't want money, you just want the court to fix the contract. All right, finally, our last 3 slides are about provisions that we put in contracts that will limit the remedies available to another party. This is another reason why we learn the law. As I've mentioned to you before, one of the reasons you learn the law is so you know what to put in your contract, so you can anticipate things that might go wrong. And if you are putting together a contract and you've just learned all the remedies that I've talked about, monetary damages, reformation, rescission, specific performance, you might not want all of those remedies to be available to another party. You might not want consequential damages to be available where you're having to pay for somebody's lost profits. If you know that ahead of time, you can put in your contract what remedies will be available if either party breaches. It's a smart thing to do. So essentially, when you put clauses in the contract that are called limitation of remedies, that's exactly what you're doing. You're limiting the remedies that are available in the event that this contract is breached. Liquidated damages. I'm putting this in here because I want you to know about it, but I'm not really going to test you on this. I'll just let you know, because this is a kind of sophisticated principle. You could also put a provision in your contract where where you determine or put a clause in that says what the top amount is that could be paid if this contract is breached. Like the party would not receive more than 3 times the contract price. These, again, I just want you to know about them, know that they exist, but I'm not going to test you on it. So they must be for a situation where it's difficult to determine damages, and the amount can't be excessive. Like, uh, so this is when you've got a contract where it's hard to know ahead of time, like what the actual loss would be if any party breached. The injured party, what the effect of putting this kind of clause in does is that it says that the injured party can't collect more than the amount that's specified in the contract. So like the draftsman is going to put a liquidated damages provision in, and they're going to put like a ceiling on how much you can get. Like, so for instance, and a lot of times you might use these in construction contracts. Like if anything goes wrong, if we breach the contract, this contract might be for $1 million. Well, the construction contract. Well, if anything goes wrong, we don't know how wrong it could go, but the top amount that you could get if we breach the contract is $3 million, like 3 times the value of the contract. So they're putting a ceiling on how much the other party could get. And these clauses will not be considered valid by the court if the sum is unreasonable. Like, so if in the industry 3 times the the amount of the construction cost, if that's not reasonable, if everybody else is doing like 5 times as much, then you might, even if this liquidated provision is in the contract, the injured party could go to court and say, yes, we agreed to this. Yes, there was a liquidated damages provision. and we knew that we would only get 3 times the contract price. But this isn't what everyone else in this trade or industry does, and this is unreasonable. That might be a way out of it. Attorney's fees. One of the most expensive parts of litigation is paying your lawyers. And under the American rule, everybody pays for their own attorney. You pay for your own attorney, you pay for your own fees, no matter whether or not you win or lose. One of the things that this does is it puts pressure on both parties to go ahead and try to resolve their conflict, because everyone is spending money on a lawyer and it's increasing the amount at stake. Now, I mentioned in class that a lot of times plaintiff's attorneys have lawyers on contingency fees, so they're not paying as much. But those contingency fee arrangements usually only apply in certain types of contracts, like personal injury lawsuits. If you are just a plaintiff who's suing for breach of contract, you're going to be paying your attorney hourly, just like the defense is. And in that case, then there is a lot of pressure on both sides to go ahead and resolve the lawsuit. It is rare, but it is, occasionally a party can ask the court, if they win, to have the other side, the losing side, pay their attorney's fees in addition to whatever else they owe. Sometimes you can get this, but it is very rare. And then finally, we have limitation of liability clauses. The content and construction. So limitation of liability clauses. First of all, they do not apply to gross negligence or willful conduct. Limitation of liability clauses are something that a party puts in the contract to put the other party on notice that we won't be responsible for certain kinds of things. And then they list what those things are. What this bullet is telling you is that the court says you can't limit your liability for gross negligence. You can't tell a party that I won't be liable if I'm grossly negligent. That's not permissible. That's not legal. But you can put in your contract that, for instance, you're not liable for certain kinds of mistakes, or you're not liable to the other party if there is a hurricane and you can't receive the product, the you know the inputs that you needed to produce the product that you were selling. Limitation of liability clauses are really good to have in place, because like they would be highly useful for companies right now, where you can put in your contract, if there is a national emergency, if there is a some sort of weather event that prevents me from being able to perform, I will not be liable for damages to you under this contract. They're also known as force majeure contracts, and you might hear about those in the news right now if you're listening. Validity. Typically, these limitation of liability clauses will be upheld by courts unless the provisions are allowing, as I said in the first bullet, they're exonerating gross negligence. Exonerate means letting off, saying that it's not responsible. As long as they don't apply to gross negligence or intentional acts, then typically limitation of liability clauses will be enforced. Alrighty, this was a lot of information in this particular provision, these provisions about breaches. Work the problems that we have in place, and we'll talk about them in the discussion, in our discussion group.